and defend our freedoms.
Yes, good morning, Your Honors. May it please the court.
Speak up, please.
Speak up.
Jeffrey Cunningham for appellant Orly Taitz.
Good morning, Your Honors. I'm Orly Taitz, and I'm representing Defender Freedoms Foundation.
Your Honors, I'd like to use a total of 10 minutes of appellant's 15 minutes and reserve 4 minutes for rebuttal.
You're married, two of you? Yeah, is this your husband?
No.
No.
No, well, what's confusing is usually two people don't stand up there. But I understand what you're saying
If
is...
he isn't, we do weddings too. If he isn't, we do weddings too.
I don't think my wife would find
No
that.
charge.
Well, but you're trying to tell us how you want to divide your time.
Yes.
But, okay, so you have 15 minutes total for both of you. You have 15 minutes for both of you. So if you're saying you want to use 10, but you want to save 4 for rebuttal, that only leaves her 1.
I'd like to use 6 and reserve 4 for rebuttal.
Okay.
He's gonna
Okay.
use 6. I'm going to use about 5 minutes. And then Mr. Marcus is going to present his case, and we'll just leave 5 minutes.
Yes, he gets the rebuttal.
Wait,
Okay.
you already used almost 3 minutes.
We'll start over.
We'll put you back to
Okay, thank you.
square one. There,
Um,
get on your
we've-
mark, go.
We've submitted several examples of plaintiffs alleging in their amended complaint that Ms. Taitz has engaged in protected
You
activity
need to sit down until it's your turn.
Yeah.
under each of the 4 categories in California's anti-SLAPP statute. Plaintiffs argue that even if Ms. Taitz engaged in protected activity, that their claims don't arise from her free speech or petitioning activity, but to the contrary, it's clear that for each instance in which plaintiffs allege that Ms. Taitz engaged in free speech or petitioning activity, there is a corresponding claim in the amended complaint based on that alleged activity. One example, there's a lengthy excerpt in the amended complaint where Ms. Taitz had given an interview on the Andrea Shea King talk radio show, where plaintiffs contend that Ms. Taitz defamed them, that Ms. Taitz was informing the birther movement community and its thousands of followers.
Can I cut to the chase with you a little bit, since we don't have a lot of time of what some of my... Now, you allege that the plaintiffs waived their choice of law argument. Is that correct?
Does this having to do with the issue of whether Pennsylvania law
Right.
applies?
Yes.
That issue is fairly straightforward to resolve, and it's resolved by looking at Judge Robreno's order regarding transfer and determining what was the
Are you
basis.
alleging she waived it? That the plaintiffs waived it? Are you alleging waiver?
We assert that California's substantive law controls and that they waive the issue because, among
So
other
the answer
reasons-
would be yes?
Yes, yes.
Okay. Now, all right, there's like 20 claims here, right?
There are 10 claims against Ms. Taitz.
All right, well, okay. Let's say if we were to find that some conduct is protected, but some is not, have the defendants met their burden under the first prong of the anti-SLAPP analysis?
Yes, we've cited cases that say that that a defendant moving under the anti-SLAPP statute does not have to show that each alleged act comes within the one or more of the 4 categories of protected activity.
Well, okay, the defendants publish private information about the plaintiffs. Why is that conduct protected under the anti-SLAPP statute? Particularly, given that the private information was not necessary to warn the public about the plaintiff's professional services or the alleged fraud.
Because it was given in the context of Ms. Taitz informing the birther movement community of the usurpation of her website. That doesn't do anything about the plaintiff's professional service or the alleged fraud. That's just saying, hey, this is where she lives, and go with, it's how is that? How does that go to your core? What you're saying, it was necessary to inform the public about the professional service and the alleged fraud. Well, as to Ms. Liberi, there was a controversy before the case was filed as to her real identity, where she contended that she was not the Lisa Liberi in question, that she was a different Lisa Liberi. So in part, what Ms. Taitz was doing was attempting to clear the record as to whether this particular Lisa Liberi was the Lisa Liberi who was a convicted felon. And this was done, again, in the greater context of informing the birther community that Mr. Berg, a prominent figure in that movement, was using a convicted felon in his law practice. In the supplemental excerpts, there's a reference to the Berg versus Obama case. In that case, Mr. Berg was claiming that he had affidavits from Africa showing that President Obama was born in Kenya. Ms. Taitz was informing the birther community that those affidavits should be looked at with skepticism because of the use of a convicted felon by Mr. Berg. And so that is the context of one incident that is protected activity under the anti-SLAPP statute. And if I could go back for a moment to...
You only have 18 seconds, and I'm going to leave this to my presiding judge here, but at 9 minutes, you're cutting into your colleague's time.
I will turn it over to Ms. Taitz at this time. Thank you.
Your Honor, I would like to stress just 3 or 4 points.
Please state your name.
My name is Orly Taitz, and I'm the president of Defender Freedoms Foundation, and I represent the foundation. So first point, there are 2 prongs to anti-SLAPP, and I'm going to start with the second one. Did they have a legally sufficient complaint? They never had it and could not have it. They filed it in 2009 under diversity, and there was never any diversity. I urge you, please look at the page. It's 2120 of the supplemental, page 2120 of the supplemental excerpt of record that they themselves, plaintiffs, provided. This is a ruling from the prior judge in Pennsylvania. And he states, in terms of jurisdiction in this case, he is stating jurisdiction for this action is predicated upon diversity of citizenship, 28 U.S.C. 1332. Then he lists the parties, and he lists their plaintiffs. Ostella and GoExcel Global are citizens of New Jersey, and then he lists 2 defendants, James Sunquist and Salt Rock Publishing, also residents of New Jersey. And the whole point is that Berg allowed this criminal Liberi to draft pleadings for him. He never went to law school. She has no clue what diversity is. She thought that just because few people are from different states, there is diversity, and there was never diversity. And what Mr. Marcus did, in his pleadings here to this court, he added, he said, the case is brought under diversity, plus there is a federal question, fair credit reporting. However, they added fair credit reporting 2 years later with their first amended complaint. You cannot
No,
create...
anti-SLAPP is very complicated, all right? And so it seems to me that the plaintiffs might, let's say if I were to conclude that they might have established a reasonable probability of success on their defamation, privacy violation, and intentional, but listen to the question, an intentional infliction of emotional distress. Do we still have to determine whether each of the plaintiffs' other causes of action state a legally cognizable claim? Because I don't think that was done.
You have to look. Claim after claim after claim. But before you even look, you don't even need to bother looking at any claims because there was never diversity and never federal court had any jurisdiction. As stated, first complaint in 2009 was filed under diversity. 2 plaintiffs, 2 defendants from the same state of New Jersey, never was any diversity. The fact that Mr. Marcos adds fair credit reporting in the amended complaint 2 years later does not create diversity. Further, another very important point, and I believe that anti-SLAPP was created for cases like this. I was the president of foundation, and there were important issues of First Amendment right.
Interestingly, I think what confuses people, it wasn't really created for any type of case. It started out where they were tenants complaining about discrimination. Maybe. But now a lot of times it's other first, and so it can be any number of people alleging First Amendment. It could be a newspaper, it could be an individual, it could be a tenant, it can be big, small people.
Absolutely, Your Honor. But what I'm saying, what did I say there, and what was stated by me or by foundation, that the website for the foundation was stolen by the former webmaster, that an attorney, Philip Burke, who was about to be disbarred, colluded with a convicted forger and thief, Lisa Liberi, and an unethical former webmaster, where they stole the website and changed the link to PayPal.
But,
so,
all right, there might be some core speech, but that doesn't mean you can do anything that you want either.
I didn't. There is nothing. There isn't a stitch of evidence in this complaint that I have revealed any information that was private, because we have, I don't know if you read everything there, but we have shown it was already res judicata, that when Judge Guilford dismissed LexisNexis, they provided Liberi's own declarations in her criminal case and her 2 petitions for bankruptcy, where she provided 2 of her unredacted social security numbers, address, all of her personal information, and she never opposed it. And on that basis, they showed that they dismissed other parties. And what I'm trying to say, that as a president of foundation, the foundation had not only the right but the duty to advise the donors. People were filing their tax returns. We had to tell them, listen, your donations are not going to foundation. They went
You're going into rebuttal time, if you want to save rebuttal time.
If I may just say, it's important. So, moreover, we had a duty to advise the donors that a convicted thief, Lisa Liberi, has now access to their credit cards. If this is not something that foundation has a right and a duty to provide, what else? And additionally, the fact that Philip Burke is using a convicted forger as his paralegal. He found 2 cases, one against President Bush, saying that he was complicit in 9/11. He filed a case against Barack Obama, saying that he has declarations from Kenya, and he went on radio show with Liberi saying, this is my able assistant Lisa who drafted the complaint against Barack Obama. So it was a reasonable exercise of speech of advising the people. His able assistant Lisa is a convicted forger who was convicted just recently of 10 counts of felony forgery and grand theft. So this is an important issue.
Save any time for rebuttal? You're using all your time.
Just a couple more points.
Well, you only have 2.5 minutes, and then you not get more.
Another
Unless the
point that is
presiding
extremely
judge does.
important, Your Honors, you have to dismiss the complaint on part of Philip Berg and law officers of Philip Berg because they never even file an appellee's brief. They never contested this case, and as such would be deemed to agree to the appeal. Moreover, we showed that law officers of Philip Berg don't exist and never existed. And additionally, in this complaint, we have shown that Go Excel Global doesn't exist from 2012. And in my opinion, this is an egregious fraud and unethical behavior on part of Mr. Marcus to continue maintaining a case from Go Excel Global, a foundation that doesn't exist and didn't exist from 2012. And we have provided in December of 2013 the record of revocation of the corporate license of Go Excel Global. And maybe you should ask Mr. Marcus, why is he maintaining a legal action on behalf of a corporation that doesn't exist for 4 years now? Thank you.
All right, you have 1 minute and 18 seconds in the bank.
Good morning, Your Honors. It pleases the court.
You want to pull it down a little bit?
Excuse me. It's my parents' fault for making me so short. If it may
I have the
please-
same problem.
That's all right.
If it pleases the court, I'm Stephen Marcus. I am representing the plaintiffs' appellees, Lisa Liberi and Lisa Ostella. We do not represent Mr. Berg.
I would like to ask a preliminary question. Is there anything in the record indicating you raised choice of law issues prior to appeal? And if not, is this issue waivable, and did you waive it?
Your Honor, I don't know if it was raised orally. I did not find it in the papers on appeal. We did not represent, or we were not lead counsel at the time that this motion was argued before. This court has the discretion to not waive that argument. This is purely an issue of law on the choice of law. And this court has the discretion to consider on a de novo review, which this is, issues purely of law where there is no prejudice to the opposing party because it is purely an issue of law.
Well, there is prejudice in this instance because under, here we have it here, and in California we have a different view on handling we apply California law in anti-SLAPP cases in federal court, and we've got precedent to that fact. Back in Pennsylvania, it's a much narrower, so there is prejudice. So now it's here, and it was never raised before, and now, you're asking us for the first time then to give you the benefit of Pennsylvania law, right?
Well, Your Honor, citing the case of United States versus Echeverria Escobar, which is 270 F3rd 1265, there are 4 exceptions to the rule of arguments not raised at the district court being waived. Exception 3 is issues presented as purely one of law, and the opposing party will suffer no prejudice as a result of the failure to raise the issue in the trial court. And there is no such prejudice here in terms of the failure to raise it at the trial court. It's raised, it's briefed, and the second is plain error has occurred and injustice might otherwise result. In this particular case, it was a diversity case filed in Pennsylvania. As a matter of law, Pennsylvania law applies.
Did the operative complaint contain any Pennsylvania claims at all?
I mean the initial complaint?
Yes.
I don't know, Your Honor. I'll be honest, I don't know.
As I read it, I didn't find any, and then this raises a question whether the panel should bar California anti-SLAPP as a defense when the operative complaint contains California claims, especially if the complaint no longer contains any Pennsylvania claims at all.
Well, it contains common law claims, which obviously are Pennsylvania common law as well as California common law. So they do involve state claims, not necessarily state statutory claims, but it does involve common law claims. It's defamation, invasion of privacy, and things of that nature. Whether some of the California claims would survive by application of Pennsylvania law and the various choice of law issues that the Pennsylvania courts would apply, I can't answer that at this time. I think that's an issue for the district court should this matter on remand be subject to a 12b-5 motion. An anti-SLAPP motion is not the equivalent of a 12b-5 motion.
Well, now, okay, if we find that some conduct that is protected, if we find that plaintiff's claims arise from some conduct that is protected, but some not, doesn't the court need to hold that defendants have met their burden under the first prong of the anti-SLAPP, and then we have to proceed to analyze claim by claim?
No, Your Honor. Again, because this is not the equivalent of a demurrer. The fact that some protected activity is incidental or antecedent to unprotected activity does not mean that the whole complaint is subject to the anti-SLAPP motion. For example, filing a pleading, an abjectly false pleading in a court proceeding is protected activity. Rebroadcasting that activity on a radio talk interviews or on a computer blog is not protected activity. The fact that the initial communication, which was then rebroadcast, might have been protected is just incidental. And the primary crux of the claim, which the court must look at, is the unprotected activity of rebroadcasting that.
Well, it seems to me that somewhere at its core, publishing, warning the public about plaintiff's professional services and alleged fraud is core First Amendment.
No, it isn't, Your Honor. Warning the public with false accusations on someone who is not a public figure. And neither Lisa Liberi nor Lisa Ostella are public figures. They were not known to the public until Ms. Taitz decided to make them known to the public.
Well, but the corruption and the fraud, that...
If it's false accusations, it's libel, it's slander, it's defamation, it's invasion of privacy. And just because you claim that you were advising the public of something doesn't make it protected activity. If that were the case, then any defamation...
Well, there's nowhere that... Is she a convicted felon? Has all these fraud... You didn't come back with anything to tell us that it wasn't true.
She was convicted of writing false checks. She's not a career criminal. She's not a career felon. She's never been convicted of real estate fraud. She is not a career document forger, as Ms. Taitz has accused her of being. And she is a private person. All she was in this case was Mr. Berg's paralegal. So we do think that Pennsylvania law applies. We don't think that the speech itself is protected activity because primarily, certainly, the invasion of privacy, the setting up of false accounts, which is alleged in the complaint and shown.
Your Honor, you stated that I have 1.5 minutes. First of
You
all,
got 1 minute and 14 seconds.
thank you. I see you're keeping time with me, but not
No,
with
but the time clock's right
No,
over there.
but not with prior parties. But anyways, Your Honors, first of all, it's outrageous that Mr. Marcus stood here and said this woman was convicted only of false checks. You have in front of you the record shows that she had indictment on 27 counts. She was convicted on 10 felony counts of grand theft. It was over $400,000 stolen, forgery of an official government seal, an offer of forged documents. And the issue is danger to the donors of Defender Freedom's Foundation, that the website was stolen, that all the donations that went through this website were diverted, and that their credit card and checking information is exposed to a woman who is a convicted thief, who was convicted of 10 felony counts of theft and forgery. That's the crux of the case. And this is a protected activity to advise this. Furthermore, they're stating identity theft. They don't even have a cause of action on identity theft. I don't know if Mr. Marcos even read the original complaint or the amended complaint. There is no cause of action for identity theft. Further on, he's stating false information. He did not...
All right, your time's up, but you seem to imply that we were only keeping track of time on you, which he did not use 5 minutes of his time. We allowed you to go over time. So you're not correct. You got every second of your time, and you went into his rebuttal time. So
No, I meant prior cases. I said prior cases before.
well, that's
me.
up to the court.
I know,
It's our
I know.
time when
Yes,
we
you're
have
right.
questions.
Yes, Your Honor, you're absolutely
All right.
right. I apologize. Do you have any questions for me?
Thank you,
No, thank you.
thank you. Very well argued. And
What? Okay.
we're going to take a recess at this time.